All right, in a moment we'll speak to Advocate Tsietsi Sebelemetja, who is the Chief Director for Legislative Development and Implementation at the Department of Justice. But we want to unpack those legal developments, those bills that have come out of the gates of Cabinet through an approval. Let me just quickly run you through some of them. We are talking about 4 bills, one of them being the General Mining Laws Amendment Bill, and that was approved on the 29th of July and approved for public consultation. So in terms of that, what it does, that bill, is it amends certain sections of various other acts. So, for example, in Schedule 1 of the Criminal Procedure Act, it now adds the offence of illegal mining, which, believe it or not, as much as we've had this problem in the country, it has not been a specified crime. So people were getting arrested for various other crimes, your trespassing, theft of minerals, etc. Now there's going to be a specific offence of illegal mining, including aiding and abetting illegal mining. That also is being inserted as far as that is concerned. It also amends the Diamonds Act of 1986 by also providing for an increase in terms of what a person can be fined for. Currently, the maximum fine, for example, for a violation of certain sections of the Diamonds Act is at 250,000 rand. That increases to about 100 million rand being the maximum that a fine can be imposed, and the number of years in terms of imprisonment from 10 years to 30 years being a possible sanction. So that's the one element that comes through. In terms of Section 5B of the bill, that has to do with mining, that is being Mining Laws Amendment Bill, it basically targets, as I said, those who are aiding and abetting illegal miners. So that comes in. Previously, in fact, the situation until now has been the role in terms of the Minerals and Petroleum Resources Development Act, MPRDA. There has been no real role for the SAPS in monitoring ongoing compliance. It was largely to a board that was designated in terms of that. That role is being clarified. It's not continuous monitoring by SAPS, but they certainly now have a role to play in enforcing compliance. But a key balance that appears to come through from the bill, the Mining Laws Amendment Bill, is seeking to balance between stamping out illegal mining, illicit mining, those words used interchangeably, and encouraging artisanal mining under licensed conditions, small-scale mining also under licensed conditions. So that becomes another element that comes through as far as that is concerned. The bill amends 4 laws, as I said: the Criminal Procedure Act, particularly Schedule 1, it adds that offence; Mineral and Petroleum Resources Development Act, MPRDA, and the Precious Metals Act, as well as the Diamonds Act that I alluded to earlier on. Illicit mining is formally linked, as you know, to organized crime. Water security threats also caused by mining damage are also recognized in the bill. So that's as far as we can go with some of the provisions of specifically the Mining Laws Amendment Bill. Let's pick up the conversation on the rest of the bills then, joined by Advocate Tsietsi Sebelemetja, who is Chief Director for Legislative Development and Implementation at the Department of Justice and Constitutional Development. Good evening to you, and thank you for your time. I suppose because we've pretty much covered the elements of the Mineral Laws Amendment Bill, I'd like for us to pick up on the other pieces of legislation. Specifically, let's cover the one that has to do with conspiracy, instigation, and the likes. It amends the Riotous Assemblies Act. Tell us the extent to which it seeks to do that and why it was time to get into that exercise of attending to the Riotous Assemblies Act in this manner.
Yes, good evening, thank you. You'll remember that this judgment, there's a Constitutional Court judgment that emanates from around 2022, wherein Parliament was given time, but then the processing of the bill was not done on that time, but however, there's a reading in. But now, this piece of legislation, there is a project within government wherein we're cleaning up the statute book getting rid of all the colonial or apartheid era legislation. And now, this is one of those piece of legislation coming from 1956 that still has 3 sections. One dealing with issues of explosives, the other one dealing with riots or things like that, and conspiracy issues. But then there are only 3 sections, and the long title to it still talks to, engendering issues around European people and the like. So it's clearly of pure apartheid colonial era. So now, as we do the review of legislation, we repeal and replace those that are still necessary within the constitutional dispensation. And the Constitutional Court did say that there is nothing wrong with dealing with issues relating to riots or so, but then it should not be for any offense, but only in instances of serious offenses. So this bill now defines what a serious offense is. In a schedule, we list those type of offenses that if one commits them will then have committed a serious offense, to differentiate them from just ordinary offenses.
I see. So that differentiation is important, isn't it? About merely committing an offense versus committing a serious offense such that it warrants intervention in the form of this bill that you've now proposed.
Yes, definitely. Otherwise, there will be no difference in anyone committing an offense. For example, there's conspiracy, there's instigation, there's incitement. So we have to differentiate between those that go commit the offense and those who incite. But the measure has to be, what is that serious offense that has been committed?
All right. Let's turn to another one, which I think will probably resonate with a lot of people. A lot of people are dealing with their property and managing their property through the establishment of trusts. There's the Regulation of Trusts Bill that you've put forward. What are you seeking to achieve with that? What gaps in the law are you seeking to plug?
Yeah. Firstly, this law is of 1987. It is now 38 years since. It has never been amended significantly or so. And in this era, there are quite a number of things that we need to do. We get into negative rating by FATF, as you would know, and we are also dealing with the issues of making sure that those who are beneficiaries are well known and we also safeguarded. Let's take example of 2 kinds of trusts that are established under this law. You can have communal property, or those that are given land back. They, instead of using the rightful legislation that is under land reform, the CPA, they then come to this trust, which is not a proper vehicle for doing that. Secondly, those that are, get into accidents or maybe medical legal issues, and they are awarded some benefits in terms of the damages. Then the lawyers will find that they open trust under this act, but then there tends to be some abuse in terms of the funds that are kept in this trust. So now this law does give some safeguards in terms of when the court decides to grant that trust to be opened by a lawyer, for example, a legal practitioner. So it has to make sure that it is the right vehicle. So we're trying to align and make sure that this trust are now becoming properly regulated in general.
Yeah, and I appreciate the complexity of it all, Advocate, and trying to cram everything into our short conversation. And I must commend you for doing exceptionally well in doing that. So let's touch then on one that affects legal practitioners, the Legal Practice Amendment Bill. And I know that there's a whole lot of provisions, but I suppose for the benefit of the public, let's touch on the aspects to do with protection of members of the public as far as monies that are stolen, abused, and the likes. What's new as far as that act is concerned?
Yeah, currently you'll know that when legal practitioners operate a trust and they tend to be theft, but then the people who then go to report it to the LPFF to claim some benefits out of the fund.
That's the Legal Practitioners Fidelity Fund, yeah?
Yes, yeah. They do not necessarily open cases criminally, but because they are given their monies back, but then the attorney is now left alone in terms of misconduct only, but not necessarily dealing with them with the actual theft, which is a criminal offense. So what you are bringing in is a requirement that while you claim, you also need to go and open up a case so that we can also criminally deal with those that would have committed theft with those trust funds.
And I saw that there's this slight distinction that now negligence as well is also being included there, not just theft, but theft and negligence.
Yes.
Yeah.
Yes, we are adding negligence because if we exclude negligence, some attorneys would recklessly or negligently handle the monies that are in the trust fund. So we're trying to give more protection to the clients, basically.
So to be clear, until now, the legal practitioners' fidelity fund would have covered instances of theft of trust monies only, and now you are adding the element of negligence also being part of what's covered.
Yes, correctly so.
All right. So tell us about the process then going forward. It's out for public consultation, these 4 bills, and all of them really touching on areas of life that many South Africans would have been looking to see greater regulation of. So what's the process going forward?
Okay, it's basically 3 that are out for public comments, which is the general mining, trust, and legal practice. The conspiracy is approved to go to Parliament. So the comments period will also be during the parliamentary session. From now on, after the 11th of September, we are going to collate, analyze all the comments that we'll have received, improve the bill where necessary, and we'll then go back to Cabinet to say, these are the comments that we have received from the public, and we have made this adjustment to all the 3 pieces of legislation. And Cabinet will then be requested to approve that we introduce the bills in Parliament. And from there, Parliament will then follow its own parliamentary procedure. There will still be an opportunity to comment again through the parliamentary process. And from there, once Parliament has processed in both 2 houses, it will then go to the President if approved, and the President will then consider assent and signature. And from there, we'll then deal with the aspects of regulations for some of the required regulations, and then we'll then implement surely from next year towards the end should all go well.
All right. I've got to thank you for coming through and explaining it all to us. That is the Advocate Tsietsi Sebelemetja, who is Chief Director for Legislative Development and Implementation, and that is at the Department of Justice and Constitutional Development.